She deserved to be catered to, deserve a vacation for just two. She deserved to be pampered, manicure, pedicure, shopping spree, yeah, that's the answer. I feel like every day is her birthday, yeah. That's just how much I appreciate her love for me. Ooh. And every holiday should be her holiday, yeah. Oh, I'd give her the whole world if it were up to me. There is nothing like a woman who takes care of a man who understands him. From all the hurt and the lies, forgiving him, there ain't nothing. There's nothing like a woman who stays prayed up for him. That's why I dedicate this song to all women. She deserves to be honored. She deserves to be catered to, deserve a vacation for just she deserves, ooh, yeah. She deserves to be pampered, manicure, pedicure, shopping spree, yeah, that's the answer. What is a man without a woman's love? She can ease his trouble and mind with one look and a simple touch. Yeah, that woman will walk for that man through hell and high. And if her love was money, I'm telling you, he's sitting on racks, on racks, on racks. And when he's ready to rash, she's ready to roll. Hey. And when he say let, she say go. Hey. See, that run explains just how I feel about these women's out here. So let's treat them with care. Oh, cause she deserves to be honored, catered to. Telling you she deserves to be pampered, manicure, pedicure, shopping, yeah, that's the answer. Now they may get on our nerves sometimes, but that's okay, cause we get on their nerves sometimes. It's the end of the day. She stayed by your side no matter what it is. There, the end of the day. Who else is gonna put up with all your shit? Who's gonna cook for you? Who's gonna clean for you? Who's gonna be by your side? Who's gonna pray for you? Who will even lie for you? Go down with you. Gotta deal with all the kids. Where do I end the list? She deserves to be honored. Deserve a vacation for just two, that means she deserves to be pampered, manicure, pedicure, shopping spree, yeah, that's the answer.
Turn this car around. Something don't feel right.
She wasn't supposed to find out about our love affair. The plan was not for her to walk right in on both of us. I did not plan for things to go down like this, that's my word. I swear I'd take it back if I could, to keep from hurting her. How could I be so stupid? Ooh, to think that I could bring somebody in our home, get away with sleeping around without you finding out. If I don't get another chance, girl, I understand, because I sent you off to be with her, but you made a U-turn. You made a U-turn.
You thought that I would be gone for a while.
You made a U-turn.
I made a U-turn.
She slipped through the back door, checked out the window, and then got in bed with her, and you made a U-turn.
Boy, you must have thought I was stupid. I was only stupid for thinking you would do this to me. When I'm gone, you're checking to see when I am coming home. But I know you're not alone, so I left the house with Stacy. Said I was going to Macy's. You gave me your credit card, blew a kiss and said bye, baby. You said buy what I want and buy something nice for Stacy. And you don't like Stacy, so I knew something was crazy. You sent me up to be with her.
You made a U-turn.
Yes, I did.
I thought that you would be gone for a while. You made a U-turn. You made a U-turn.
She slipped through the bag.
I gave you money plus my car to go on shopping spree.
Tell me what good is your money if you're gonna lie to me.
Sometimes I lie just to get you out of the studio.
What?
And she would be down there stripping for me in the studio.
Oh no,
I know it's bogus shit,
but why'd you do this, Kelly? You said you loved me, but how could you hurt me?
you made a U-turn.
You thought I'd be gone
I thought that you would be gone
for a while.
You made a U-turn. You made a U-turn.
Emotional.
Yo. It's late, so I ain't gonna drag it all the way through. Let's get into it. Real quick. Let's get into it. We got a lot to get into. Motion to dismiss the indictment for pre-indictment delay comes now. Defendant Darryl Mcdavid, by and through his undersigned attorneys, Bo B. Brindley and Vladimir A. Glozin, and pursuant to Fed R. Crim P. Rules 12 and 48 and the Due Process Clause of the Fifth Amendment of the United States Constitution, respectfully moves this honorable court to dismiss the indictment due to pre-indictment delay. In support, the following is offered. Introduction. The government has stretched this case well beyond reasonable limits while attempting to bring an indictment against Mr. Mcdavid. It tries to criminalize events that allegedly occurred decades in the past. But in the years since these events purportedly occurred, vital pieces of evidence have been lost or destroyed. Key witnesses that would have aided Mr. McDavid's defense have died. Worse, the government knew about these very same allegations when they allegedly occurred 20 years ago and physically possessed some of the evidence that is now lost to time. Yet, it repeatedly declined to bring any charges for years and waited until the 11th hour to bring a case after substantial pieces of the evidence were already lost. As a result, Mr. McDavid is deprived of his constitutional right to prepare a complete defense and his right to a fair trial. As the law says, justice delayed is justice denied. That legal maximum is in full force here. The indictment must be dismissed because of inexcusable and unnecessary pre-indictment delay. Legal standard. While the statute of limitations provides a primarily safeguard against overly stale charges, it is not the only constitutional protection to a prompt trial and administration of justice. United States versus Marion case law. Explaining that the statute of limitation does not fully define defendants. Does not fully define defendants' pre-indictment rights. Indeed, the due process clause forbids pre-indictment delays and requires dismissal of the indictment when the pre-indictment delay caused substantial prejudice to the defendant's right to a fair trial. Marion case law. United States versus Spears case law. Stating that the due process clause assures that the government does not subject a defendant to an oppressive delay. In fact, the right to prompt and fair justice even predates the Magna Carta and is deeply ingrained in our criminal justice system because it is well established. It is a well established fact that a trial conducted years after the alleged commission of an offense inevitably suffers from impaired fact finding. The court must employ a two-step balancing test to determine if the pre-indictment delay violated Mr. Mcdavid's due process rights. CID at United States versus SOA. United States versus McMurtry case law. First, the defendant must show that the prosecutorial delay caused actual and substantial prejudice to the defendant's right to a fair trial. Henderson case law. The defendant must show actual and substantial prejudice, not mere speculation. McMurtry case law. After this, the burden shifts to the government to come forward and provide reasons for the delay. SOA case law. This court then balances the government's reasons against the prejudice suffered by the defendant to determine if the delay violated due process. And the government does not have to act intentionally or in bad faith for this court to find a due process violation. If the prejudice to Mr. Mcdavid's right to a fair trial outweighs the government's reasons, it does not matter that the government acted intentionally, recklessly, or even negligently. United States versus Williams case law. Explaining that the government's unintentional delay may still require dismissing the indictment if the delay is so detrimental to the defendant's case as to be patiently unfair. Sabbath case law. At 1018, explaining that the core holding of SOA is that pre-indictment delay is determined by a balancing test, not a rigged set of fault. United States versus Lawson case law. Noting that the government conceded that a prosecutorial delay occurred in reckless disregard of the circumstances known to the prosecution would violate due process. United States versus Ross case law. Allowing pre-indictment delays based on negligent prosecutorial acts. Howe versus Barker case law. Finally, a defendant may establish the prejudice caused by the pre-indictment delay both before and during the trial. See Fed R. Crim P. 12B3A2 statute law. Allowing pretrial motions to dismiss for pre-indictment delay. Marion, 404 U.S. at 326. Stating that events at trial may demonstrate actual prejudice of pre-indictment delay. For example, in United States versus Gliss, the district court took pretrial motions to dismiss the pre-indictment delay under advisement and ultimately terminated the trial once the prejudice became apparent. 594 F2D 1374 1377 case law 10th Circuit 1979. In addition, Rule 48 allows this court to dismiss an indictment if an unnecessary delay occurs in presenting the case to the grand jury or bringing a defendant to trial. Fed Crim P48B. While the Rule 48 standard is not circumscribed by the Sixth Amendment right to a speedy trial, it is driven by the same general considerations United States versus Ward case law argument. The government's delay in prosecuting this case is inexcusable. It has consistently stretched and twisted its allegations to try and bring a case against Mr. Mcdavid. In particular, the government has bent over backwards trying to allege a factual basis for the obstruction of justice conspiracy, the centerpiece of their indictment, that was not barred by the statute of limitations. Still, even under the government's theory, it only managed to obtain the indictment with a handful of months remaining on the clock. Nevertheless, the heart of the government's case concerns allegations that occurred decades ago. At its core, Count 5 alleges a conspiracy to create false documents and records in the DFCS investigation occurred in 2000, and a Cook County grand jury occurring in 2002, over 20 years prior to the start of this current trial. Docket 93, pages 10 to 11. The most recent false document was allegedly created in 2007, over 15 years ago. ID. See also Doggett versus United States, 505 case law. Explaining that the prejudice presumed from a pretrial delay intensifies over time, and over the years, evidence in the government's possession has apparently been lost. Witnesses who have offered testimony supporting Mr. Mcdavid's defense have died. The witnesses who will testify undoubtedly will have faded memory of these long past events. See Barker versus Wingo case law. Explaining there is prejudice when witnesses can no longer accurately recall events of the distant past, and this loss of memory is not always reflected in the record because what has been forgotten can rarely be shown. As a result, Mr. Mcdavid has been stripped of using vital pieces of evidence as witnesses, leaving him with inadequate alternate means of preparing for his defense. This cannot and should not be the case. The Supreme Court has long held that a defendant is prejudiced by an excessive and unnecessary pre-indictment delay when he suffers the loss of evidence from death or disappearance of witnesses, destruction of documents, or failure of memory. Marion case law. And this is precisely what Mr. Mcdavid suffers from here. Over time, the government has apparently lost the original version of video 1, which is essential to count 5. Mr. Mcdavid needs that actual video to point out the things on it that were shown to him before the 2008 trial. Things which shaped his knowledge and his beliefs regarding the 2008 trial and 2002 grand jury on which the obstruction of justice charge focuses. Further, there were defense documents and evidence held by Robert Kelly's attorneys from the prior state proceedings that have been destroyed in the years after his case ended. Once the 7 years mandated for keeping files and records passed, documents critical to Mr. Mcdavid's defense were destroyed. These were documents establishing his relationship to the attorneys on whom he relied on for his beliefs and knowledge about this case. These documents include documentation regarding the obtainment of videos that the government now tries to falsely blame on Mr. Mcdavid. Not only this, but numerous witnesses have died in the years in between the events giving rise to the charges and the trial in this case. See United States versus Burkett. Finding actual prejudice when multiple key witnesses died during a 4-year pre-indictment delay. One of the most critical witnesses who will undoubtedly be mentioned throughout the trial was Jack Palladino, an investigator. Palladino was present for critical events in this case. He was present for the obtainment of a videotape. that the government now falsely claims was received by Mr. McDavid. Palladino could have established that Mr. McDavid received no tape, that he was not present when the tape was handed over. But because of the decades of delay, Palladino has died before this case was brought. Had it been brought in even a remotely timely manner, he would have been alive and been able to testify. I don't like the way this is going. I don't like this the way this is going, because now Darryl McDavid done turned on everybody and trying to blame everything on Kelly. Let's go ahead and read. Despite the government's claims and prior motions, the original version of video 1 is essential to the obstruction conspiracy charge in count 5. As previously explained in prior motions, the charged false documents and records were created in response to the original version of video 1 that the witnesses were shown in the 2002 grand jury. It is only the original version that matters here, for the jury to determine whether the defendants truly believe whatever videos they were allegedly shown had minors in them or not, which is critical to any evaluation of whether they obstructed justice. They must be shown the same version of the video that the witnesses and defendants could have viewed back in 2002. Only then can they fairly and accurately evaluate the reasonableness of the defendant's belief about what the video contained. Likewise, the original videos Kelly's defense team used in the prior state proceedings to create reports analyzing the videos and suggesting that they could have been altered are also lost and destroyed. Those items on which Mr. McDavid based his knowledge and beliefs about the video recording at question in the 2002 case are essential to his defense. But after Kelly's case ended in acquittal, the records were destroyed. After the mandated 7-year retention period, these documents too would support Mr. McDavid's defense and help prove that he did not act with the requisite intent. See Gliss case law. Affirming finding of factual prejudice based on lost documents and investigative files being scattered among many people and officers. However, they are lost due to time and delay that was by no means necessary. Palladino, the defense's investigator, would have also offered testimony to reinforce that these documents show impacting and jury's determination of Mr. McDavid's intent. He was hired to investigate the allegations against Kelly and was present for crucial events that will be hotly contested at this trial. For example, an essential component of the government case involves an alleged contract to receive a tape by individual B. Palladino was allegedly acting as an agent for Kelly and Mr. McDavid. His testimony would have contradicted individual B, a government cooperator, and a large portion of the case would have hinged on what he said. See SOA 34 case law, affirming finding that the defendant suffered actual prejudice because he could not recall the events of the offense after the pre-indictment delay. At the same time, this pre-indictment was entirely avoidable. The federal government was in actual possession of the original version of Video 1 when it first surfaced in the early 2000s. Facts. Both Chicago Police Department and FBI reports clearly state that FBI agents viewed and were sent the original VHS tape that contains Video 1. CEG 711-2002 FBI ROI, 6/7/2002 CPD ROI. In fact, at the 2008 trial, a state witness testified that the original VHS tape was sent to FBI agent George Scalaba to analyze, and he had sent them back to the state investigators and possibly initialed the tape to confirm the chain of custody. See People versus Kelly. Oh, Jesus. trial transcripts, pages 164. Ooh. The testimony also suggests that Skaluta indicated in his report that he could not identify Kelly. Oh. Ooh. Oh my God. The testimony also suggests that Skaluta indicated in his report that he could not identify Kelly. So if you can't identify Kelly in video 1, how in the hell can you do it now? Yet now the government contends that they have no way to tell what video that was or if it even exists. Moreover, the indictment alleges that there was another agreement to retrieve a tape that involved individual C and individual D. The government was also aware of this allegation for over a decade. Investigators interviewed individual D about the allegation back in early 2008, when she made similar accusations to those alleged in the indictment. Despite possessing the tape and having known about the allegations for decades, the government declined to bring charges. Indeed, it declined to do so on multiple occasions. See 10/3/2005 FBI RI closing the Kelly investigation. At 5/31/2018 FBI RI closing the case file on new accusations against Kelly. Instead, it did nothing while being fully aware of the allegations and possessing evidence for decades. As a result, they let substantial pieces of evidence get lost to time. Even according to their allegations, nothing has changed. They are the same allegations as they were before, but now Mr. Mcdavid has been deprived of significant evidence he needed to prepare his defense. The prejudice he suffers from due to this pre-indictment delay has deprived him of the right to a fair trial, and it outweighs whatever reason the government has for such an unnecessary and excessive delay. See Sabath case law. Dismissing the indictment due to pre-indictment delay because, in spite of the prosecution's knowledge about the circumstances surrounding the investigation, ill-prepared reports, elderly and sick key witnesses, a case agent who passed away, faded memories of the government's own investigative agents, and missing physical evidence, the government consciously delayed seeking an indictment for a mere 4 years. The indictment must be dismissed. Conclusion. Wherefore, defendant Darryl Mcdavid respectfully moves this honorable court to dismiss the indictment and enter any other equitable relief that deems just under the circumstances. Okay, let's see what comes next. Okay. Let me see. Oh, they already talked about this. Oh, we already talked about that. Okay. But from the one I just read, here's the order. Darryl held and continued to 8/16/22 at 10 a.m. There might not be a Chicago trial. There might not be a Chicago trial. Because now, as of today, since that was put in, look what he said. Darryl held and continued to 8/16/22 at 10 a.m. Oh boy, here we go. And the date on that was yesterday. Man, this is about to be crazy. And Darryl is the formal examination of a prospective juror under oath to determine suitability for jury services of the prospective witnesses under oath to determine competence to give testimony. Leavenweather has been put on a hot seat. Because now he got to make a decision. Because what can really happen... Hold on. Let me look. Because what can really happen... Hold on. Because what can really happen... Yeah, this is about the tape. Yep. This is about the tape. Yep. They calling the government out. Hold on. Let me look. So the judge said voir dire began. Wow. So I guess he's gonna have to give a ruling on that. Only thing he said is voir dire can begin. I don't think in my honest opinion, if he have to rule on that, I don't think it's going to be a case. Because that right there just hit on the head. And if I'm not mistaken, that applies to Robert and June. Let's see. Oh, shoot. Hold on. Okay. Yep. So the judge don't want to rule on that. I think they might go into it tomorrow for open discussions. This is going to be weird. This is going to be weird. This is going to be weird because what I just read really called the government out. And they called them out on something crazy. But that's good, bro. Tomorrow Leader Sports Network stepped in the building. Yeah, he is 85 years old. So, let's see. Because if that motion applied to Darryl Mcdavid, it applied to all three. Let's see how they rule on it. All right? Told y'all I'm going to bring an indictment to y'all. I'm out. Y'all be blessed. Peace.
Swimming in you. Hey, little mama. Said I wanna take her. Dipping your pool. Just go for a little dive, yeah. Hey, yeah.
Bye.